Good morning, everyone. Thank you all very much for coming from far and wide to join us this morning for a very needed conversation on criminal law reform here in North Carolina. My name is Christopher Hansford. I am Director of State Relations for the Cato Institute. For those of you that are not familiar with Cato, we're based out of Washington, D.C., and are a pro-liberty, pro-free market, and pro-peace think tank focused on expanding these ideas on a multitude of issues. And my work has taken me and continues to take me across the country, talking in different states and bringing together needed coalitions on different issues. And we're very happy to be here today in North Carolina, partnering with our friends at John Locke, who are, bar none, the best that we have seen in the country when it comes to tackling these issues and bringing together a broad coalition of folks. To quickly speak about Cato's interest in being here and why we are very happy to partner with John Locke on this conference is Cato has taken a deeper interest, especially as gridlock continues to be ever present in Washington, D.C. I'm sure you have noticed in the past few years that continues to be a trending theme in our nation's capital, that the real opportunities to improve people's lives, bring real reform, and make measurable advances in liberty and honest justice are represented here at the state level. And we appreciate all of you being invested stakeholders and partners in this process by being here today. The Cato State Leaders Initiative, something that we have kicked off here in 2019 at Cato, is focused on identifying partners like John Locke who can help advance meaningful coalitions that represent the spectrum of ideas and can bring real change here in your states. I thank you again all for joining us, and it's my great privilege to introduce Becky Gray, Senior Vice President from John Locke.
Thank you, Christopher. Thank you all so much for being here and for being interested in this issue. Those of you that are familiar with our work at the John Locke Foundation know that we don't shy away from big challenges, big ideas, big, bold ideas, and real significant reform. As a matter of fact, we embrace it. So where many states have looked at this, tried to do this, even the federal government really has an interest in this whole notion of simplifying, making our criminal code easier to understand, simpler, fairer, more efficient, and more effective. No one else really has been able to do this of what we intend to do over the next several years. So thank you for being here. Thank you for being interested in this idea for us. Everyone in this room has a part to play in this. I mean, we've got such a wide array of lawmakers, people from the judiciary, people from academia, leaders across our state. So you are the folks who can get this done. So we're very much looking forward to this discussion throughout the day. I want to just say a special personal thank you to my good friend Jim Copeland, who you'll hear from in a few minutes, and my friend Jesse Smith, both of whom were at the forefront of this whole idea of you can make a criminal code that's more efficient and better serves the people, and have just been instrumental in developing and pushing this idea along so far. So I'm looking forward to all this great discussion. We'll have Q&A after each of our segments, so don't be shy about answering the questions and participating in this discussion. This day is not meant to be a lecture. It's meant to be a real engaged conversation throughout the day. I want to thank, too, my colleagues, John Guzet and Mike Sheetselt. John is the Director of Legal Studies here at the Locke Foundation, has been driving this project, and Mike Sheetselt has joined the Locke Foundation as a fellow focusing specifically on criminal law reform. So without them and their direction, I wouldn't have anything to say here. So thank you so much, and I'm going to turn it over to John, who I believe is going to lead our first panel.
Thanks, Becky. Thanks, Chris. And thank all of you for coming. In your folders, you'll find extended biographical statements for the three panelists who you're about to hear and for all the panelists you're going to hear from today. So I'm going to keep the introductions brief. We've assembled 3 experts to explain why we need criminal law reform in North Carolina. And they are, starting from my far right, Jay Schweikert, who's a policy analyst with the Cato Institute's Project on Criminal Justice, Jim Copeland, who's a senior fellow and director of legal policy at the Manhattan Institute, and as Becky said, Mike Sheetselt, who's our criminal justice fellow at the John Locke Foundation. I'm going to let Jay start it off, but before I do, I just want to mention one thing about Jim Copeland. His report called Overcriminalization in the Overcriminalizing the Old North State was, it brought these problems we're talking about today to the attention of a lot of people in North Carolina, including me, and I don't think we'd be here today if it wasn't for that report. There's a copy of it and some more recent Manhattan Institute reports out on the table at the entrance. Jay, will you get us started? I don't know.
Happy to do either way. I think probably everyone can hear me pretty comfortably, but I'm happy to talk.
Well, why don't you come sit here?
Okay. Microphones come up. Oh, we got it.
Oh, microphones. All right, then you can stay where you are. I'll have to stand. That's fine.
I'll get up there in a sec.
Okay.
Got the slides.
Good, Jim, thanks.
Okay, this is on? Okay. Generally don't have to do this myself. Let's see if I can show it. Okay. Let's see, can folks hear me okay? Okay, well, thank you very much for that introduction. My name is Jay Schweikert. I'm an attorney and I'm a policy analyst at the Cato Institute's Project on Criminal Justice. It's a real pleasure to be able to speak to all of you today on this issue of criminal law reform. One thing that I often say when I discuss really criminal justice issues more generally is that I'm often filled with a sense of both extreme pessimism and extreme optimism. The pessimism because I really do think that the criminal law and criminal adjudication in this country represent perhaps our very most serious public policy failures. I think just a couple basic numbers to kind of put in perspective the significance of what we're talking about today and why this is so urgent. A lot of you may already know that the United States is the most incarcerated country in the world. Not among Western democracies, in the world. Out of every 100,000 individuals, about 730 or so are incarcerated at any given time. The next highest is Russia at 615. Now, North Carolina actually in particular is a little bit better on that front. It's in the mid 300s, but that still is only behind Russia and Ukraine, I believe. So I think that, there's no single cause of that. It's a complex problem, but for a country that is the land of the free and has really robust legal and cultural protections for individual liberty, that should be shocking and very concerning. And then I think relatedly, another point is that if you ask people, from a sense of what they learned in, so their government classes or from watching TV, how we resolve criminal cases, people would probably naturally think of jury trials. That is supposed to be the means, that is the constitutionally prescribed means by which we adjudicate criminal cases, the public adversarial testing of evidence before ordinary members of the public. And we have all but eliminated that from our criminal justice system. Nationwide, about 97% of all convictions are obtained through plea bargains. And in North Carolina, it's actually even a bit higher. It's 98%. So the means, the constitutionally prescribed means, that institution that has been sort of the crown jewel of the Anglo-Saxon system of law predating Magna Carta, has been all but eliminated from our criminal justice system. Now, those are very large structural problems, but the reason that I think criminal law reform in particular is so crucial to these is because that is really the starting point for everything else in the machinery of criminal justice. We're not specifically here talking about like policing practices or bail practices or criminal adjudication or plea bargaining, but all of those issues are informed by what you decide in the first instance is a criminal law in the first place. And in fact, most of the time, when I'm talking to people about those other issues, I have to kind of remind them to say, look, we can talk about ways to reform these issues on their own, but you can't do that in any kind of complete sense unless you go back to the beginning and talk about what have we decided to criminalize in the first place. And so I think it's absolutely essential that the conversation start there, which is why I think this is such a great opportunity. And on that point, I think that it's worth just I'm here to provide a little bit more of a sort of national general perspective, I think. And I think it's worth taking a step back and thinking, what is it that we really intend to be doing when we decide something should be treated through the criminal law? Because, in my view, and I think this probably matches a lot of the sentiments of people here, criminalization and with the potential for incarceration is often crucial and necessary for public safety, but it's an extreme remedy and a blunt instrument. And that once you've decided to put something in the criminal law, you are triggering the machinery of criminal justice at every step down the line. You are involving the police, with all of the potential risks of escalation and the cost both to officer safety and public safety of using that of police investigations and arrests. You are treating this through the system of criminal adjudication, where what you are supposed to have is a jury trial, but with often very strong incentives to sort of short-circuit that process through plea bargaining tactics, which can often be coercive, can often result in innocent people pleading guilty, can often prevent the members of the public from having some sense of what their criminal justice system is actually doing. So I think that we've gotten to a point where we often use the criminal law as kind of a knee-jerk first response to perceived social ills, as opposed to recognizing it as a necessary but extreme remedy for the most serious circumstances. So I think that this project of really identifying just how expansive the criminal law has gotten, and taking a step back to think, is this worth it? Is this worth the cost of investigation, enforcement, and adjudication? Is this worth the human and financial cost of incarceration, not just to the person who is convicted, but to the family and job and community that they're taken out of? Is this something that we are willing to spend the time and resources to at least potentially adjudicate through a public jury trial? And then I think also, is this something where we can eliminate redundancies and overlapping offenses, which I think are major contributors to what I see as the problem of coercive plea bargaining? I think that those are absolutely essential first steps. And I think over the course of the day, we're going to talk a lot more about some of the technical ways to do that, how to identify the offenses that we want to, have actually be identified as criminal. But I think as we're doing that, it's important to just keep in mind that this is not a technical discussion that we're having, right? This is not fixing things up, making things, a little bit clearer. This is addressing the fountainhead of problems throughout our criminal justice system. And if you can get that part right, if you can start off with meaningful, identifiable criminal laws that address people who are morally culpable and present serious risks to the community, and not go further than that, that in and of itself is going to, I think, effectively address a lot of these downstream problems that are much harder to address on their own. So that's what I think is at stake in this conversation. That's why I think this is so important. And I'm very honored and proud to be a part of that discussion with all of you today.
All right. Thanks again for having me as well. I'm super happy to be here. The folks at the John Locke Foundation said nice things about me. I'll say nice things about you. I deal with a lot of these state think tanks committed to free markets and individual liberty, personal responsibility. And John Locke Foundation is and has been a gold standard among those state organizations. So I really appreciate the opportunity to be here. I've been working with the Locke folks on this 4 or 5 years now. I think I spoke down here the first time 4 or 5 years ago on this issue when we released a 2014 report that I co-authored with my then colleague Isaac Gorodetsky. I've also spoken at Cato on related issues at the federal level, some of the work I've done on federal deferred prosecution agreements. Big fan of the legal team at the Cato Institute, so I really appreciate the invitation here. Manhattan Institute's been working on issues related to the criminal law and regulation through prosecution since its earliest days. I really sort of turned to this early in my time at Manhattan Institute. Eliot Spitzer, our then Attorney General, was reshaping industries through some of New York's criminal laws. In 2012, my sort of first foray looking at this at the state level was a book chapter that I was asked to write for the Heritage Foundation's book edited by Paul Rosenzweig and Brian Walsh, One Nation Under Arrest, looking at New York. And then we decided to look at this more systematically. Well, we found some of these issues coming up in New York. Are they also in other states? And North Carolina is my native state. I actually live now in New Bern. So we were interested here, but that's not why we picked it first necessarily. There was a young scholar at UNC School of Government, Jeff Welty, who was doing work on a law review article that we discovered on this issue. And we said, wow, we should talk to Professor Welty and maybe come up with some methodologies and import some of his ideas and try to jumpstart discussions on this. And we did this with a number of other states, and just last summer, we synthesized these findings in a report we entitled Overcriminalizing America, an overview and model legislation for the states. So I just want to thank all these folks that we've worked with, Locke, Cato, Heritage, Mackinac up in Michigan, Buckeye in Ohio, Texas Public Policy Foundation we haven't worked as directly with, but they've done a lot of thought leadership here. Of course, Jeff Welty, the American Legislative Exchange Council, has been very cooperative with us on this. Our findings are essentially that overcriminalization is a problem, and that's true whether you're talking about blue states like Minnesota or New York, purple states like Michigan and North Carolina, red states like Oklahoma and South Carolina. Some folks may disagree on the margins with those characterizations, but they're relatively fair. The point is, no matter what the politics are of the state, we see elements of this cropping up. When I talk about overcriminalization, what do I mean by that? And the basic answer is it's the rapid expansion of what falls under the criminal law, particularly these sorts of economic regulatory crimes that aren't intuitively thought of as criminal. We know that murder is wrong. We know that rape is wrong, assault, robbery, burglary. We don't know that having the wrong form filled out is wrong. We don't know that having the wrong size of box or container is wrong. It's not intuitively criminal, and we've largely eliminated some of the criminal intent requirements that are traditionally embedded in our criminal law. Now, what's not overcriminalization as I think of it, it doesn't involve these traditional violent and property crimes, murder, rape, assault, robbery, larceny. And this is where I want to put a caveat on what Jay was saying about things like incarceration in the United States. It's really not related to that too much when you look at the numbers. 5 and 6 individuals in state prisons are there for 8 traditional common law crimes that we were talking about, these intuitive crimes. Most of the rest are there for narcotics or drug offenses. And I tend to think overcriminalization is a little separate from that too. We can debate about drug policy. It's a separate issue though. People know that heroin, cocaine, marijuana are illegal. We can debate about the way we police that. But it's a sort of separate issue to what we're talking about with overcriminalization. I do want to emphasize that notwithstanding that most folks aren't in jail for these crimes or imprisoned for the long term for these crimes, innocent individuals do fall under them. They're not generally who we think of as white-collar criminals. Big businesses, remember, have legal compliance teams. They can follow the law much more easily than your small business owner, your family farmer, your sole proprietor, who often are unknowingly falling under the ambit of these exploding number of crimes. For instance, Stephen Pruner here in North Carolina spent 45 days incarcerated for selling hot dogs from his cart in front of the Duke University Medical Center without a license. And a lot of these sort of licensing offenses are the things we're talking about that create impediments to people who maybe aren't that sophisticated but want to try to make do for themselves. Sometimes it's just neighborliness. Lisa Snyder in Michigan came under the authorities' inquiry when all she was doing was helping her neighbor watch her kids for 5 or 10 minutes before they got on the bus because the neighbor had to get to work. And the state came after her for practicing daycare without a license for doing this. Colin Grizzle in Oklahoma was serving vodka infused with bacon and pickles and flavors. Now, there may be public health reasons to regulate this or whatever, but he probably shouldn't have been prosecuted criminally for it, we wouldn't think. And he certainly wouldn't necessarily know how to find, as a bartender, wouldn't know how to find out that he was violating Title 37, Chapter 3, Section 584 of the Oklahoma Code. So the problems when we're looking at overcriminalization really are there are too many crimes, people can't follow this. The crimes themselves are often poorly drafted, they're outmoded, they're vague, they're not codified in a logical way. There's no criminal intent requirements protecting us if we unknowingly violate them. And then often the lawmakers are delegating their authority to create crimes to outside bodies, including private bodies. So too many crimes, this is a bedrock principle of our country, as James Madison from the Federalist Papers. We can elect our officials, but if the laws are so voluminous that they cannot be read or so incoherent they can't be understood, what good does that do the average citizen? And when we've looked at all these states, you can see the model penal code. This is sort of the model drafted by the poobahs at the American Law Institute, law professors and practitioners who some people think are worthy of deriving these sort of model rules, but they have 114 sections. All of the states we've looked at have a lot more than that in the penal code, the criminal code, which is only a small subset, ironically, of a lot of the crimes. North Carolina is kind of in the middle there, but in the 700s. And the average numbers of crimes created annually is pretty profound when you think about it. I mean, those 8 common law crimes are where 5-6 of our prisoners are going to prison for, but we're creating 20, 30, 40, 50, 60 crimes a year in most of these states. North Carolina is on the low end here, 34, on the high end of the percentage that are felonies, which may mean they're looking at things that are more under the traditional criminal law ambit more than the economic crimes. It could be a good thing, but that's a lot of new crimes. If you're talking about half of 34, that's 17. That's a lot of new felonies every year for North Carolina to be creating. Now, the outmoded and poorly drafted crimes, this shouldn't be surprising either. You add to the volume, you're just going to get mistakes made. The number of imprecise laws is going to grow. Sometimes they're just duplicative. So in North Carolina, when we were looking at the new laws being created over a several-year window we were studying, we found that vandalizing or stealing portable toilets was one of the new crimes. Now, porta-potty theft might be first of all, we ought to outlaw porta-potty theft, and we ought to outlaw vandalism, but there are already laws on the books to do that. And so maybe there should be a sentencing enhancement or something if we've got a raft of porta-potty thefts, but we didn't think it necessarily needed its own separate law in a different part of the North Carolina codes. Minnesota, and this is sort of the blue state version of this, they have a statute prohibiting drug and alcohol counselors from imposing on their clients any stereotypes of behavior, values, or roles related to human diversity. Now, I don't know what that means. I think I know what they're trying to get at, but you're going to prosecute someone criminally for that? It's so subject to different interpretations. The judges will probably end up saving an individual if they're actually prosecuted under it, but nobody's really on notice. And sometimes you just have these outmoded laws. So we'll make fun of our friends to the south in South Carolina. It's still a crime there to practice fortune telling without a license. Now, we don't know how you'd license a fortune teller, and not clear that they've ever enforced this, but it's on the books. Codification, confusing codification, and Mike's trying to figure this all out, and we'll talk about the specifics there more in a minute here in North Carolina. But as you can see, all these states are passing new crimes, the majority of which are outside the criminal code. So they're in the vast sort of regulatory, administrative state sphere. North Carolina is at the bottom of this. This is sort of the flip side of the felony thing. So some of these other states, they're passing a lot more misdemeanor crimes in regulatory codes, but all of them are passing a lot. All of them are passing a majority outside the criminal code. So if you take all the statutes and it's war and peace and you're trying to get the average person to figure this out, you're still not going to be able to do it if you're an average sole proprietor, small business owner, family farmer. Because even if you looked at the entirety of the North Carolina code, all the laws, you'd be missing all the municipal ordinances, which are often criminal. You'd be missing the standards set by various private review boards like the dentists or the whatever else, public health officials. All sorts of agency rules, government official rules, etc., aren't in the code, but they're criminal based on the way they've been defined under state statute. And you're not going to be able to get out of these by saying, I didn't know I was doing anything wrong. Now, this is what Jay was talking about, a foundational part of American jurisprudence. Oliver Wendell Holmes says even a dog knows the difference between being kicked and being stumbled over. But we've lost this principle when it comes to criminal law. So traditionally, you had to have a guilty mind for these common law crimes, which of course it makes sense. Nobody commits murder or assault without a guilty mind. But these sort of technical infractions, the courts basically said, well, we can't really do that. We let them get away with it. And so we've lost some of these traditional standards. A lot of our research has shown that state lawmakers regularly don't specify any criminal intent standard whatsoever. In Michigan, a majority of misdemeanors, that was the case. We had a scholar like Mike there from Mackinac who sort of spent a year looking at all of these things and counted them up on the criminal intent standards. State courts have regularly sort of inverted this principle so that if the state legislature doesn't say anything about criminal intent, they assume that it's a strict liability crime and there's no intent requirement at all. And then finally, a lot of state legislatures do this. They have this sort of default criminal lawmaking where they say any municipal regulation or ordinance, any administrative ordinance, any decision of this or that body becomes a crime, which sort of departs from our basic consent of the governed principles from the Declaration. So when we were fighting the British, we said no taxation without representation, but we're regularly creating crimes without representation, or at least only a very attenuated tie to the voters. The legislature passes the default statute, leaves the details up to somebody else without ever reviewing the substance of these crimes. So here in North Carolina, you have these statutory catch-all provisions in the areas of public health, agriculture, environment, rules and regulations being promulgated over and over. This General Assembly is never reviewing them. They have criminal teeth. And that extends to private licensing bodies in medicine, dentistry, nutrition, various areas. And sometimes people get caught up in these sorts of things. We're also trusting these private bodies who have every incentive to create impediments to competition. So the dentists, and this was something that went up to the Supreme Court of the United States, the dentists said, well, we can't have teeth whitening kiosks in some stores. Is that a public health concern or not? It's something that at least the legislature ought to be debating. It's not something we ought to leave up to the dentists to decide the rules for their own competitors. And essentially none of these provisions, creating catch-alls, delegating criminal lawmaking outside the legislature, have any criminal intent requirement at all. Oklahoma, here's an example, the Pet Breeders Act, 20 pages, more than 43 sections after a broad delegation there. And so, wait, I'm going backwards, aren't I? Sorry. What do we do now? Basically, we want to protect the individuals who unknowingly violate the law. We want to make it easier for ordinary people to understand the law. We want to recodify where we can, including making criminal offenses civil when that's more appropriate. And we want to better ensure that elected legislators are themselves considering the specific crimes before people can be actually imprisoned for them. And so we came up at the end of our report with 5 basic principles here, bringing back criminal intent standards, mistake of law. We've worked on other states with these, and then North Carolina has really gone into the hard work of 3, 4, and 5 here, which is reorganize the law, repeal a lot, destroy this delegation away from elected lawmakers. And Mike's the one who's been doing a lot of the hard work on that, so we'll hear from him next. Thanks.
A lot more comfortable. Is this on? I'm a lot more comfortable sitting down rather than standing behind the podium. So my name is Mike Sheetzelt. I am the legal fellow at the John Locke Foundation who has been tasked with taking on this project specifically. And as John said, it was a lot of Jim's work that kind of provided the groundwork here, but another paper that was put out a few years ago that has really focused us on recodification is Professor Smith's white paper on recodification in North Carolina. And she drew a lot of attention to these problems and has provided a lot of the basis for me to kind of sink my teeth into this code in a very short amount of time. I've been with the John Locke Foundation since February. I really appreciate Cato joining with us, partnering with us on this today, and giving us kind of a platform to speak about this, because it's of critical importance. I mean, Jim just delved into a lot of the reasons for overcriminalization and a lot of examples for it. Overcriminalization isn't a new problem, though. Overcriminalization was something that Blackstone was writing about in the 1760s when he talked about laws that, laws that forbid anyone to be seen for 1 month in the company of persons who call themselves or are called Egyptians. There was a capital punishment imposed for cutting down a cherry tree in an orchard, which gives a kind of a whole new meaning to that story about George Washington being perfectly honest with his father about cutting down the cherry tree. And the reasons for overcriminalization that Blackstone identified are very much the same as what you just saw on Jim's slides. Rigid adherence to obsolete laws, too little attention in framing and passing new laws, asymmetries in sentencing that arise from shocking news stories or from frequency, trying to deter a frequently committed act. So this is something that's been around for a while, and I think we have an opportunity now to start to tackle it. And recodification is the first step in tackling that. To speak specifically about North Carolina's criminal code, Professor Paul Robinson, who is, I believe, at the University of Pennsylvania right now, is an expert on American criminal codes generally. And about 20 years ago, he teamed with a couple of co-authors to write a paper that ranked 52 criminal codes, all 50 states, the federal criminal code, and the criminal code of the District of Columbia, based on some factors that were more or less objective as you can get when assessing a criminal code. So he laid out 5 different questions. He assessed how clearly the rules of conduct and adjudication were laid out, how consistent the grading was from one crime to another, and to skip straight to the bottom line of this study, North Carolina ranked 43rd out of the 52 criminal codes, which should probably tell you we did pretty poorly on most of the questions that they assessed, but one that stands out to me is the very first question he asked: does the code contain a comprehensive statement of the law's commands? North Carolina scored terribly on this question. North Carolina was the only state that scored worse was West Virginia. We were in a 3-way tie for 49th, if anybody cares, with Rhode Island and the District of Columbia. But this is troubling because according to the authors and according to Professor Robinson, a state that scored poorly on this question has in many ways hardly a criminal code at all. It's more akin to a patchwork full of holes. And I think that's an apt description of what we're facing in North Carolina right now. So I guess to understand why we fared so poorly on this question, we have to ask a more fundamental question. What is our criminal code? When a lot of these scholars dig in and they start studying our criminal code, they look to Chapter 14. And I think when you ask people what our criminal code is, that's the most logical answer. Chapter 14 is the criminal law chapter of the general statutes. And I think at our last count, there were something like 874 crimes that were found in these statutes of Chapter 14. But I think there are 3 major reasons why that's an inadequate answer. Chapter 14 is inadequate. The first is because it's not the foundation of the criminal justice system at all. Chapter 14 sits on top of the common law, and many of our offenses that are listed in Chapter 14 don't have a definition at all in Chapter 14. They still have their common law definition. So larceny is still defined as it was at common law. Robbery is still defined as it was at common law. Arson is still defined as it was at common law. And so if you look through the sections of Chapter 14, you realize that a lot of these crimes are simply add-ons to these definitions. Jim mentioned larceny of porta-johns, but I think you could look at other, I don't know if that would be considered real property, but the problem here is that larceny is the theft of personal property. And so there are more than a dozen sections of Chapter 14 that just add real property onto that. So you have larceny of ungathered crops, larceny of certain kinds of animals, larceny of other kinds of animals, larceny of ginseng, larceny of pine needles, larceny of home fixtures. And so you get these added on top of it, and you wind up overwhelming the system with inputs. Common law arson, same thing, malicious burning of a dwelling. So you have a whole bunch of sections of Chapter 14 that add non-dwelling buildings to the definition of arson. And so you get gin houses, you get auxiliary structures, tobacco houses, public buildings, schools. All of these fall under different sections of Chapter 14, and it becomes impossible to wade through what most people see as being the primary document in our criminal code. And not only is the common law the basis of these what we call malum in se crimes, it's also the basis for many of our defenses. A lot of justifications and excuses don't find a definition in our criminal code. I think insanity is one particular example where we don't have a statutory insanity defense in Chapter 14. So the second reason why Chapter 14 is probably a bad proxy for our criminal code is that those 874-ish crimes that can be found in Chapter 14 represent only about a third of our statutory crimes. There's more than 2,500 that can be found tucked away in more than 140 chapters of the general statutes. And the more sophisticated people might say, well, you go to Chapter 20 for your motor vehicle offenses, or Chapter 90 where we've codified the Controlled Substances Act. But then you have to look to more obscure corners. I don't know how many people here are familiar with Chapter 63 on aeronautics, but there are crimes throughout Chapter 63 where we've punished trespassing on airport property or malicious tampering with an aircraft, in addition to crimes that perhaps are more specific to licensed pilots, like not performing stunts over a public gathering. A third and finally, the statutory crimes in Chapter 14 are dwarfed by the crimes that you'll find in municipal codes across the state. We have roughly 550 towns and cities that all have their own code of ordinances. And we have another 100 counties that have their code of ordinances. And all of these ordinances are made criminal by default, or most of these ordinances are made criminal by default, unless the local jurisdiction opts out. And so you have roughly 650 different jurisdictions across the state with a different criminal code. And it makes it impossible to pin down from town to town, from city to city. And these ordinances criminalize all kinds of behavior. Some of them we would think of more reasonably, noise ordinances, a violation of a noise ordinance, particularly in a college town, or the development ordinances, or begging or sleeping in a public park, the ordinances that tend to criminalize poverty. But you also have some of the more frivolous prohibitions against using silly string in town limits, or wearing thong bathing suits, or failing to have a screen on a window in your house that opens and closes. These are all criminalized in at least one jurisdiction across the state. This state of affairs makes it remarkably difficult, bordering on impossible, for even the most attuned stakeholder to know what the criminal law is. I'm talking about judges, attorneys, legislators, scholars who have put together a massive resource on criminal law statewide. It's tough to keep up with this. So how much more difficult would it be for the average citizen to become even generally oriented with the criminal law in North Carolina? I think this system runs afoul of even the broadest conception that one might have of what is fair notice when we start criminalizing trivial behaviors and not just the malamente, the robbery, the murder, the rape, the things that we think of as being inherently evil. Our criminal justice system still holds to the maxim that ignorance of the law is no excuse. And I think that there's a corollary duty for our legislators then to make sure, as Madison said, that the laws don't become so voluminous that they cannot be read, or so incoherent that they can't be understood. And so recodification is a first step, and it is only a first step, to ensuring that we don't wind up suffering from overcriminalization and its negative effects long term. And beyond that, there will be future discussions, but recodification is a huge first step to fixing that issue.
Well, we're running a little late. I want to make sure we have time for questions, but let's just thank our panelists first, because I think they all did a really great job. Are we going to circulate microphones, or are we just going to let people shout? What do you think, Anna? In the meantime, who wants to ask a question of these panelists? Anyone? Yes, ma'am.
There's been a suggestion to sunset laws after a certain amount of time so they can be revisited to determine whether they should still be on the books as our society changes. What do you think of that suggestion?
You want me to take it?
I mean, my instinct is that these sunset laws make a lot of sense if we're talking about the regulatory code of crimes, what is called malum prohibitum crimes, which basically means you don't allow, it's bad because it's prohibited, which is pretty circular, right? And obviously we don't want to sunset laws against murder, these sort of common law crimes, or things like that. But I think there's a lot of value in it. There's some states experimenting with it, and Mike can talk about areas where North Carolina's been looking at this.
Well, there was one proposal earlier this year actually to place a sunset on many of the local ordinances, and we met quite a bit of resistance with that particular proposal, and I think that's reasonable. I think that there's a lot that needs to be considered, particularly about this delegation, before we try to wipe things out piecemeal. If there's not a better system in place, it could have significant negative effects. But, I mean, a lot of the overcriminalization problem is simply a problem with inertia, getting people to revisit what's already on the books. Once laws have become obsolete, or once the dust has settled on perhaps a particularly devastating news story, and we've got this new crime, this shiny new crime to fix this horrible problem that we saw on the news, and once the public outcry from that has died down, perhaps we should come back and revisit these kinds of crimes to ensure that, that they are actually needed. And like I said, recodification is a first step. So there are all kinds of mechanisms for providing that kind of oversight and providing that kind of review, to make sure that periodically we go back and we cull what's not needed and keep what is needed.
And I would just add one additional reason I would say it's so important to have those very strong mechanisms in place for culling obsolete laws is, you talked a lot about notice, and I think that's obviously very important. I think it's a key principle for all the reasons you've mentioned. But I think another, maybe even more fundamental issue there is that a lot of these sorts of laws threaten not just the ability of citizens to understand the criminal law, but the very legitimacy of the criminal law itself. When you have such a wide scope of criminalization, even if, I take the point is well taken that like most people are not in prison for having silly string, right? I mean, I think there is sort of a, first thing, if you're in a hole, first thing to do is stop digging, and so given the state of incarceration, it's probably important not to make that any worse. But I take it it's not accounting for the majority of people actually in prison at any given time. But I do think that when you have laws so widespread that cover so much innocent or trivially wrongful conduct, it turns ordinary, otherwise decent law-abiding people into lawbreakers, and basically teaches them it's not something that's worth taking very seriously. The fact that your legislature or your municipality has decided to prohibit something is not really worthy of your respect. Police officer, and it puts, I think, law enforcement in an incredibly difficult position of having to enforce laws that the community does not have any respect for. That naturally is going to create tension. It's going to increase the risk of officer safety, because even minor incidents can escalate. So I think notice is a key part of it, but it's not just because, if only you could magically know everything, you would just follow it all and it would be acceptable. Criminalizing, using the strongest tool of state enforcement that we have for such minor offenses really puts the legitimacy of the entire system at risk.
I think, if I may really quickly, just to add on to that, a colleague of mine, Joe Coletti, gave me a great soundbite just a couple weeks ago, and we were discussing the issue of overcriminalization and undercriminalization. And he said, in a system with undercriminalization, you have people who think just because it's not illegal doesn't mean it's not bad. With overcriminalization, right, you have just because it is illegal doesn't mean it's wrong. And that threatens that public trust and confidence in the rule of law.
And to build on what Jay was saying as well, in terms of putting the police officers, whatever, in enforcement, most of these new laws aren't getting enforced, right? I didn't bring this up on a slide, but when we studied North Carolina, 2/3 of the new crimes that the legislature has been created over the next session of the legislature, the next 2-year window, 2/3 of them, there was not a single enforcement of the crime. So the crime was added to the books and then just sat there.
I think we had another question out here.
Yeah, I guess I'm trying to draw the connection between Mr. Schweikert's sort of opening statement and then what the two of you, the theoretical problems seem pretty clear, but how does this sort of porta potty issue connect to thank goodness we're right there with Russia, in terms
Sure.
of I'm struggling a little bit to see, because as you just said, if these things aren't getting prosecuted at all, I do agree that sort of your average citizen is looking and sort of throwing up their hands maybe to a certain degree, but what's the connection there?
So yeah, I think it's a good question, and I guess what I would start by saying is that I bring up the state of incarceration and that we're so close to Russia as evidence of a much larger problem. and problems that, frankly, I think are not specifically within the scope of the recodification proposal here, right? I mean, a lot of those do involve, I think, sentencing questions, right? I guess what I'm saying is that that should be a very serious wake-up call that criminal law in general, I think, in this country is run amok, right? And that it's addressing that, I think, should be the top priority for lawmakers at every level of government. And so I think that, recodification is a first step. And I think part of what I think is behind this proposal is a sense of, let's ensure, a certain degree of moral culpability before we sort of turn to this extreme tool to address social ills. I think sort of these first steps probably are not, in and of themselves, going to address the state of mass incarceration. But I think it's part of changing the presumption, changing the mindset around what we use the criminal law for. And I think if we can get that nailed down and basically say, okay, now we know what the laws are, we're pretty confident that there's a sound basis and principle for punishing these, I think that then gears us up for having more meaningful conversations about how we're adjudicating them. Whether this is going through the plea bargaining system or going through jury trials, whether the sentences are appropriate. I think before you can really have a meaningful discussion about the sentencing, though, you should have a pretty good sense of what the criminal laws are in the first place. So I agree it's a much larger question than what we're specifically talking about with some of these regulatory offenses. But I think it's a necessary first step towards addressing the much larger problems with the criminal law.
And to follow up on that, first of all, when you say they're never enforced, that's not the case, right? There's a lot of laws made that aren't enforced. The enforcement's low, but there's still enforcement here. You just don't have long-term incarcerations off of this. But it creates a lot of impediments and uncertainties for the entrepreneurs and small business owners and family farmers and everyone else. And it's barriers to entry for people who want to set up a hot dog stand or whatever, which isn't to say that there shouldn't be some licensing for that at all, but we ought not put people away if they're unknowingly violating those sorts of laws. But to some degree, your question gets at probably a little bit of disagreement on the panel here, and a little bit of a sort of conservative libertarian schism in the way we look at this. I would argue that the reason why the United States has such sky-high incarceration rates is because we have higher violent crime than the other developed countries, and we have better capacity to enforce the law in terms of violent property crime than the developing countries. So we have a lot higher violent crime rates than the European Union and Japan. We have better capacity to enforce than places with higher crime rates like Jamaica or Brazil or what have you. So I would argue that the best way to cut incarceration is the way we did it in New York, which is to cut the crime rate, and then incarceration can fall. And that's a hard thing to do, but it's really quite separate from this sort of, I think, umbrella of economic and regulatory crimes that we're talking about here. And what's good about this issue is you can actually get right-left agreement, you can get libertarian-conservative agreement, you can actually get some sort of agreement, and there's really not a great counter-argument to saying, let's make the law clear, let's think about whether these things should be those that we're holding people morally culpable for with the criminal law. Let's make sure we're thinking about the intent required for this law. Let's make sure people are put on notice. These are because these are the sorts of things we ought to all be thinking make a lot of sense.
Well, we're running late. Mike, I want to cut you off because I want to have time for one more question, sir.
Will there be a greater discussion of property crimes in the course of the discussion over the next couple hours?
I really don't know. We're going to have to all find that out, but if there's not, you can ask a question then, I guess. We've got a 50, I'm sorry, one last question.
One question. So it seems to me that a lot of the type of crimes you're talking about come from horse trading within the General Assembly. So you have somebody from a jurisdiction that has a friend who's a great contributor who has a hot dog stand, and then they don't want anybody else competing with their hot dog business on the streets. And they bring that law forward, and then they trade a vote to get support for this law. So when you talk about a delegation, does that delegation review the proposed laws in addition to looking at recodification to ensure that we're not adding more of these to the books going forward?
So to address, I guess, the first premise there about horse trading, I think that's perhaps one explanation, but this is a complex issue, right? So as I guess as I said earlier, the common law had a lot of holes that we've had to plug over time. And rather than simply say, you know what, we're just going to recodify larceny so that it encompasses personal property and real property, we've just added real property bit by bit over the years, and it's caused this to stack up. So it's a complex problem that there's no one good explanation for why the criminal code is in the state that it's in. I mean, another potential reason for this is the delegation in Section 14-4 that makes most municipal ordinances, the violation of most municipal ordinances, a Class 3 misdemeanor, dates back to, I believe, the 1870s. And, you know, back then we didn't have a unified court system. Counties were administering their own court system. And so there are relics all over the criminal code. To delegate the review out, and it may be a group of members of the General Assembly, it might be the General Statutes Commission. I don't know who, and this is all up for discussion. I think everything's on the table right now. Somebody needs to go through and look at these crimes periodically. If there's a delegation to municipal or administrative bodies, there needs to be someone looking over it and saying, you know, perhaps we're taking this a bit too far when we criminalize the use of silly string, or we criminalize not having a screen in the window of a house. There are valid reasons for delegation, there are valid reasons for oversight, and we just need to be cognizant of that as we move forward.
Okay, we're going to break it off here. If you would try to get back by 11:15, we'll get back on schedule, and then we can have lunch on time. Thank you.